So, a false representation is a false assertion. But not every false assertion is a false representation, because a representation is an assertion of fact. An assertion of fact as opposed to an assertion of opinion. Hey, we all talk about our opinions all the time, and really nobody has a right usually to rely on our opinions. So if I say, looks to me like it's going to rain tomorrow, I may have made an assertion, but I have not made a representation, because a representation is an assertion of fact. Now, yes, a representation is an assertion of fact, but not every assertion of fact is a representation, because a representation is an assertion of fact which is made for the purpose of inducing the plaintiff's reliance. Suppose, for example, that I'm about to go out on a date and I really want to impress my date with how important a person I am, and I say, you see this car that I'm taking you out in tonight? Well, this car has bulletproof glass in it because I'm so important that there are always assassins after me, and I had my car equipped with bulletproof glass. Now, my car really is not equipped with bulletproof glass, but I'm just saying this to impress my date. My neighbor happens to overhear the conversation, and he always wanted a car with bulletproof glass. And he just heard me say that my car has bulletproof glass. So the next day he comes to me, he says, Fins, I want to buy your car. And I say, okay, I'll sell it to you. He buys my car and then finds out the day after that that the glass in it really is not bulletproof, and he sues me for misrepresentation. Did I make a false representation? Well, I made a false assertion of fact, but I didn't say the glass was bulletproof for the purpose of inducing my neighbor's reliance. I didn't even know he was listening. I made the statement for some other reason. I made the statement to impress my date. Since I did not make that assertion of fact for the purpose of inducing the plaintiff's reliance, I did not make a misrepresentation or a false representation to that plaintiff, and I could not be liable to him for the tort of misrepresentation. So the first element of that tort is a false representation, and we see that that means a false assertion of material fact made for the purpose of inducing the plaintiff's reliance. Now, I talked about a false assertion of fact, and then I used the word material fact. What is a material fact? A material fact is a fact that the reasonable person would care about. So if I was selling you my car and I said, this car used to be owned by a person named John, the chances are, even if I were telling a lie, I wasn't making a misrepresentation, because the reasonable person really wouldn't care whether the car used to be owned by a person named John or a person named Mary or a person named Dave. So although I made a false assertion of fact, it wasn't a material fact, and my false assertion was not a false representation. All right, let's look at the next element, which is fault. All jurisdictions agree that if I knew the fact was false when I asserted it, I had the necessary fault. By the way, what do we call it if I know something in the law of torts? Well, we call it intent. And so, if I knew the fact was false when I asserted it, I made an intentional misrepresentation. And all jurisdictions allow the plaintiff to recover if my misrepresentation was intentional, so long as the rest of the elements are present. In addition, however, about half the jurisdictions, maybe a little more than half right now, allow the plaintiff to recover if I made a false assertion which I did not know was false, but I should have known was false. What do we call that kind of a misrepresentation? We call it a negligent misrepresentation. Here comes that basis of liability called negligence again. Negligence is a breach of the duty to use reasonable care. So, if when I made an assertion to you, I owed you a duty to be careful about the assertions I was making, and I wasn't careful about the assertions I was making, then I have made a negligent false assertion or a negligent misrepresentation. And a little more than half the jurisdictions will allow the plaintiff to recover in a case of negligent misrepresentation. Now, why do you think all jurisdictions don't allow that? Why do you think there are some jurisdictions that don't allow recovery for negligent misrepresentation? Well, you already know the answer, but you might need a little help to remember it. A little while ago we said that in general the rule is that there is no negligence liability for business losses or lost profits. Most of the time, in a misrepresentation case, that's what the plaintiff is trying to collect. Business losses or lost profits. Hey, you sold me this thing, you told me it was a bar of gold and that would have been worth $1,000. It turned out to be a bar of some other kind of metal and it's only worth $100. I had a $900 business loss as a result. The general rule is that there's no recovery for business losses that result from negligence, but a little more than half the states are willing to make an exception for negligent misrepresentation. And so, when we talk about the tort of misrepresentation, we're really talking about two torts. Intentional misrepresentation, which is accepted in all jurisdictions, and negligent misrepresentation, which is accepted in a little more than half the jurisdictions. Incidentally, remember that negligence isn't just unreasonable conduct. Negligence is a breach of the duty to act reasonably. So very often, in negligent misrepresentation cases, the courts consider the question of whether this particular defendant owed this particular plaintiff a duty of reasonable care. And if the defendant did not owe the plaintiff a duty of reasonable care, then the defendant cannot be liable for negligent misrepresentation, even in jurisdictions which recognize negligent misrepresentation. The classic illustration of that comes from the cases in which accountants are hired by their clients to prepare audits that indicate how much money the client has. The accountants know that that audit is going to be used by the client when the client goes to someone else in an attempt to borrow money. So I'm an accountant. You're my client. You come to me and say, Fins, prepare an audit for me. You hire me to do that. You pay my fee. I prepare the audit. You then take the audit to the first bank and say, lend me money. Here's a statement from my accountant saying how much money I'm worth. The bank looks at it, they say, looks to us like you're solvent, and they lend you the money. It turns out I made a mistake in preparing the audit, and so the bank sues me for negligent misrepresentation. Some courts would say that I did not owe a duty to the bank because the bank was not my client, and therefore I can't be liable to the bank for negligent misrepresentation. Other courts might say that since I knew that somebody like the bank would be relying on the statement I prepared for you, I did owe the bank a duty of reasonable care, and therefore I could be liable to the bank for negligent misrepresentation. You see, everything we learned about the basics, the basis of liability called negligence, for example, comes back to work for us later on when we get into more specific areas of tort liability. The third element in a misrepresentation case is the plaintiff's justified reliance. Reliance means that the plaintiff believed the representation and acted on it, changed his or her position as a result of that representation, used it as part of the decision that he or she made. That's what reliance means. So if the plaintiff didn't believe my assertion, the plaintiff didn't rely on it. Or if the plaintiff did believe my assertion but decided not to buy for some other reason, the plaintiff did not rely on it. Even if the plaintiff did rely on it, however, misrepresentation liability is imposed only if the plaintiff was justified in relying. That means only if the reasonable person in the plaintiff's shoes would have relied. If I told the plaintiff an obvious lie, I said, look, buy this Cadillac. It used to be owned by President Abraham Lincoln. And the plaintiff is fool enough to believe that story and buy the Cadillac and then find out later that Abraham Lincoln died decades before automobiles were even invented, and the plaintiff sues me for misrepresentation, the chances are the plaintiff is going to lose because the reasonable person would probably not have believed